Option contracts are one way to make offers irrevocable. Hi there, I'm Professor Seth Orenberg, and today we're going to learn about the basics of option contracts and how they make offers irrevocable. Just a word at the outset, this lesson is general in nature. There are specific option contracts out there, such as ones to purchase stocks and bonds, but this is a more general concept applicable to all of contract law, because almost anything that could be subject to a contract could also be subject to an option contract. And this lesson will also talk about ways that offers can become irrevocable without an option contract. Option contracts are contracts. They're formed in the ways that contracts are formed, with the exception of a few special rules. In this lesson, we will discuss what exactly are option contracts, both in terms of their form and their function. And we'll go over some special rules you'll need to know about when option contracts can be formed as a matter of law. An option contract, as the name implies, is a contract. So just like any other contract, it requires offer acceptance and consideration, except when it doesn't. We'll get to that. But what makes an option contract special is that it has a particular function. Option contracts limit revocation of a different offer. As we'll discuss in a minute, offers are generally freely revocable, but parties can agree to make an offer irrevocable by paying consideration. That would create an option contract that limits the revocation of another offer. As I mentioned, an option contract is a contract, and all contracts require three things: offer, acceptance, and consideration. Option contracts require these things too. So a bare promise to keep an option open for 30 days that is not supported by consideration is not an option contract. Please see my other videos on offer, acceptance, and consideration to better understand these terms as they apply to contracts in general. The offeror, the person who makes the offer, is the master of the bargain. This means the offeror sets the terms of the bargain and also has the power to determine how the offer can be accepted and even to revoke the offer so it can no longer be accepted. The general rule is an offeree's power of acceptance is terminated when the offeree receives from the offeror a manifestation of an intention not to enter into the proposed contract. In fact, the ordinary offer is freely revocable, even if it expressly states the contrary. To limit the power of revocation, there must be something more than a mere gratuitous promise to keep the offer open. There are three ways that an option contract can be formed in order to limit the power of revocation. The first is through consideration, just like any other contract. Offer, acceptance, and consideration are required for a contract at law, and option contracts are just that, contracts, so they also require offer, acceptance, and consideration. We'll see two examples of that in just a minute. Firm offers are a special rule under the Uniform Commercial Code that only pertains to merchants selling goods. And there is a special rule under common law that part performance of a unilateral contract will also create a quasi-option contract at equity. We will cover those each in turn. First, let's look at a simple illustration of an option contract that is supported by consideration. Please read the screen. Albert promises Bart that Albert will sell Bart his car for $10,000 at any time within 30 days that B selects. In return, Bart pays Albert $100 now. The exchange of $100 for the promise to keep the offer open is an option contract that makes the offer to sell the car irrevocable for 30 days. Let me illustrate how this is supported by consideration. Albert is making a promise to Bart. He promises to keep an offer open for 30 days. Bart is making a return promise to Albert. Bart is promising to pay Albert $100. Since we have an exchange where both people receive something for value, we have consideration. And since there is offer, acceptance, and consideration, we have a contract. It so happens that this particular contract is an option contract, one that limits the power of revocation of another offer. But just like all the contracts we see at law, it is supported by consideration. Here's another illustration where there's no consideration, but a bare gratuitous promise. Please read the screen. Albert promises Bart that Albert will sell Bart his car for $10,000 at any time within 30 days that B selects. 2 days later, Albert sells his car to Carly instead. Albert did not breach his promise to Bart because his promise to keep the offer open was not supported by consideration. Let's illustrate this. Albert is making a promise to Bart. Albert is promising to keep an offer open for 30 days, or in other words, Albert is promising to make his offer irrevocable for 30 days. But what is Albert getting in return from Bart? Nothing. There is no consideration for this promise. It is a mere gratuitous promise, unsupported by consideration, and so it cannot form a contract. We will learn that contracts can be formed without consideration, pursuant to some special rules. But none of those facts are present here, and so this option contract, quote unquote, is unsupported by consideration and therefore not binding. Under the Uniform Commercial Code, an offer by a merchant to buy or sell goods in a signed writing, which by its terms give assurances that it will be held open, is not revocable, even if it doesn't have consideration, during the stated time or if no time is stated for a reasonable time. In other words, merchants have a special power given to them by statute. They have the power to make contracts without consideration. These particular kind of contracts, firm offers, are enabled by the Uniform Commercial Code Section 2205. In addition to forming an option contract at law through offer, acceptance, and consideration, or an option contract at statute for firm offers by merchants who sell goods through a signed writing, there is a third way to make an offer irrevocable, at equity. This equitable doctrine of quasi-contract holds that where an offer invites an offeree to accept by rendering a performance and does not invite a promissory acceptance, an option contract is created when the offeree tenders or begins the invited performance or tenders a beginning of it. In other words, we make an offer irrevocable as a matter of equity or fairness and form a quasi-option contract where there are three things present. First, we evaluate whether the offer is one that can only be accepted by complete performance. Such an offer is called unilateral. Second, we determine whether the offeree began performance or merely prepared to perform. And third, we have to establish what is a reasonable time for the offeree's performance. Surely the offeror did not intend the offer to remain open forever. Let's look at an illustration to better understand performance. Please read the screen. David offers to pay Emily $100 if she finds his lost dog and brings him home. Emily searches for the dog and finds him, but David revokes before she brings him home. David breached his promise to Emily. By searching for the dog, Emily began performance of this unilateral offer, making it irrevocable for a reasonable time. Let's contrast this with another illustration where there was no performance. Please read the screen. David offers to pay Emily $100 if she finds his lost dog and brings him home. Emily Googles how to find a lost dog. Meanwhile, the dog returns home and David revokes the offer. David has not breached his promise to Emily. Googling is probably not beginning performance. She is merely preparing to perform. Moreover, once the dog returns home, Emily's complete performance is impossible, so she cannot accept the offer anyway. Let's recap. The ordinary offer is freely revocable, even if it expressly states the contrary. However, the power of revocation is limited where an option contract is supported by consideration, there is a firm offer by merchants, or there is part performance of a unilateral offer. I hope this video helped you understand option contracts and ways in which offers can be made irrevocable. Thanks for watching.